Yes. This hearing is in the matter of case numbers CFI 107-2021 and CFI 108-2021 before Her Excellency Justice Maha Mheiri. The claimants are represented by Mohammed Circle Advocates and legal consultants. The lead counsel is Yash Behru, and the defendants are represented by Davidson and Co. and the lead counsel is Anson Shirong. Thank you very much.
Mr. Yash, your application.
Yes, good morning, Your Excellency. I am
Mr.
Behru, acting on behalf of the claimants in both matters. Ms. Chung, who you can also see on your screen, acts for the defendants. Your Excellency, as you will appreciate, the application today is my application for permission to amend the particulars of claims in both sets of proceedings. May I just check, before I move into my submissions, whether Your Excellency has had the opportunity to read both mine and Ms. Chung's skeleton arguments?
Yes.
I will, for the purposes of my submissions moving forward, rely on what I have set out in my skeleton arguments, and what I'll do, Your Excellency, is provide you with the references as I move through those submissions. By way of very quick background, the court will be aware that there are two parallel proceedings in which the defendants are the same in both proceedings, and there's an overlap of some of the claimants. That's what we refer to as the 107 and the 108 claim. The underlying facts to both proceedings are very similar, which is that the claimants made a number of private investments by way of convertible loan agreements, under which monies were paid by each individual claimant to the first defendant, which is a company based in the BVI. The purpose of those investments was to fund the company's capital and operating expenses. Now, the monies were provided by way of interest-bearing loans. However, each claimant had the right to convert all or part of its lending into an equity holding in either the first defendant itself or another company identified within those agreements. So for the purposes of these proceedings, there are two loan agreements that are in issue. There's one which is dated the 15th of February 2018, and that's in claim 107. And there's a second agreement which comes later on, dated 24th of October 2018, which is the subject matter of claim 108. By way of reference, you would have seen the first one is referred to as CLA3 in the documents, and the one in October 2018 is sometimes referred to as the bridge loan. Your Excellency, each of those agreements is signed by the second and third defendants on behalf of the first defendant, and it's also signed by the second defendant in his personal capacity, who has also initialed every single page of those two agreements. They are in the bundles. I don't propose to take you to them for the purpose of today, but the reference for the February 2018 one is A21, and the reference to the second one of October 2018 is B20, should Your Excellency wish to revisit those in due course. Now, further to those agreements, the second and third defendants also executed deeds of guarantee in favour of each claimant, guaranteeing the punctual performance and the obligations of the first defendant. Now, we say that the claimants in both sets of proceedings allege that the first defendant has simply failed to repay any part of the loans due under both of those agreements, and the second and third defendants have failed to guarantee those payments by stepping into Wellness's shoes and making the payment where they failed to do so. So, as such, Your Excellency, the main claims pursued by us are a debt claim and a claim for breach of contract. What we now seek is permission from the court to introduce an alternative claim in restitution, which is entirely parasitic to the main claims. And what I mean by that is that the alternative claim is based on identical facts as the ones we've advanced in respect of the debt and contractual claim. And it is only a claim that we're pursuing in the alternative should those main claims fail. What I propose to do now is address you on the proposed amendments for which we seek permission. Your Excellency, I plan to structure my submissions in the following way. Firstly, I would like to take you through some very selective documents that puts into context why we are having to apply to amend the particulars in the first place. Secondly, I will briefly address you on the test and the relevant factors that the court must take into account when considering whether to give permission or not. And lastly, I'll take you through the proposed amendments in both particulars of claim and address you on why they meet the threshold requirements. Now, there is, of course, an overlap between the two particulars of claim, so I don't plan to devote the same amount of time to each. Once I've taken you through one, I'm hoping that will save us some time in respect of the others. So if I may turn to my first point, Your Excellency, both particulars of claim were originally filed in these proceedings on the 13th of December 2021. That is almost 3 years after the loans had matured under both agreements, which were both due for maturity on the 31st of January 2019. The reason for the long gap between when the loans matured and when a claim was eventually issued is largely due to the generous forbearance of my clients, but also the repeated assurances from the second defendant that the loans were in fact due under both loan agreements and they would be repaid. Now, I just want to take the court to some of those communications, those pre-action communications between the parties, because that helps put into context why the claimant did not have cause to believe that they had a claim in restitution at the time it was issued. Rather, all that they were entitled to do at the time was pursue a contractual claim and a debt claim. I've set out my submissions on this point at paragraph 29, subsection 3 of my skeleton argument. But Your Excellency, if I may first turn to A33, and I believe I can direct you to that page through case line. Let's see if this works. Does Your Excellency have A33 in front of her?
Yes.
Yes. So this is an email from the second defendant to all of the claimants on the 22nd of January 2019. And Your Excellency, this obviously is about a week or so prior to the loan's maturity. Now, as you will see in the first sentence, it says, all as we initiate the DD process for your potential equity investment in WU, which is the first defendant, may I please propose that we stand still on the retirement of the loans for 60 days till 31st of March 2019. And we can see right at the top under the logo Gmail, the subject matter of this email is short-term extension of convertible loan. So prior to the maturity of the loan, we can see an email that is specifically acknowledging the indebtedness of the defendants because he's asking for a standstill on its enforcement. And there's no suggestion in this email that there's any issues with the validity or the enforceability of the agreements that have been entered into. The next email I wish to take you to is on A34. And again, I'm hoping that has come up on your screen. This is an email from the third claimant, Mr. Blegian, to the second defendant, dated the 28th of April 2019. And we can see it's the second part of it. It's a forwarded message. We can see it's from Andre, and you can see it's to Jacob Logothetis, which is the second defendant. And this records a telephone conversation that took place between the claimants and the second defendant. And if we look at the first heading, it says lending extend to the end of June. Thanks, Carlo. JL, which is the abbreviation for the second defendant, is absolutely planning on the possibility that we will not convert. If we look at the second heading, investors IM, the fourth bullet point down, looking to raise 5 million USD, rough figures, and then underneath that 1 million for our potential retirement. So what this email shows, pursuant to the discussions that took place, is that there was an agreement the loans, the repayment of the loans would be extended from January until the end of June. But this is also a record of the defendants looking to raise funding in the sum of 5 million, of which 1 million would be to repay the claimants the outstanding loans. Now, the amount outstanding from the defendants to the claimant under both loan agreements around the time of this email was around $947,000, and that's set out at paragraphs 29(3)(c) of my skeleton argument. So the figures roughly accord with what was owing to all of the claimants under both agreements. Approximately a year after this, we get another email. And again, I'm just going to bring this up. It's at A37. It's an email chain dated the 1st of March 2020. And we can see there's an exchange between Alex REUTER and the second defendant. If we look at the email below, this is the email from Mr. REUTER, the first claimant. He says, "We don't want to spend any further energy on this, therefore we will not engage in any new documentation and will simply rely on you repaying us on 10th of May all outstanding amounts. I hope and appreciate the trust we put in you. I've attached a spreadsheet that calculates the outstanding amounts. Please can you confirm these outstanding amounts will be paid on the 10th of May. And if we look at the breakdown of the calculations, Your Excellency, that amounts to, by my calculation, about $1.125 million that is owed. And we can see from A38, A39 and A40, it breaks it down per loan and per claimant. And Mr. Logothetis's response is above, which is he responds to Mr. REUTER and say, both Angela and I executed the doc that acknowledges these figures in the deed you received today. At first glance, I don't see any changes between WU summaries version 1 and version 2. Please elaborate if you've changed anything. Yes, your trust is appreciated and these amounts are outstanding and will be covered by 10th of May unless the world changes as we know it. So again, this email shows that they were always working as one and dealing with the monies due under both agreements together. So it deals with the money owed under both loan agreements. It shows how much is outstanding at this time. And you can see the second defendant is specifically referring to the fact that he and the third defendant had executed a document that acknowledged the indebtedness and the figures and confirms that these will all be repaid on the 10th of May 2020. So, Your Excellency, of course, the loans were not repaid by May 2020, and that's part of the reason we're now where we are. However, the dialogue continued up until formal demands were issued by my clients on the 14th of November 2021. Again, I don't propose to take you to those demands, but for your reference, it's at A49 and B49 in the bundle. Your Excellency, what I say is what is consistent in the pre-action correspondence we've just seen and the others that I haven't taken you to, is that the second defendant accepts and acknowledges that a debt must be repaid to the claimants, and he never so much as intimates that the loan agreements were invalid or unenforceable or there's any other issue in respect of its performance. So it is against this backdrop of signed and initialed agreements and repeated assurances that the debt would be paid that the claimants issued the claim in the form that they did in December 2021, which was a claim based entirely on contract and debt. Now, Your Excellency will of course know and be familiar with the fact that restitution claims based in unjust enrichment are generally only available where there is no valid contract governing the relationship between the parties and one party has been unjustly enriched at the expense of the other. That simply was not the case here. At the point of issuing the claims, the claimants only believed and had every reason to believe that the two loan agreements and the two guarantees governed the relationship between the parties, and therefore that forms the basis of which they could pursue this claim. With that context in mind, Your Excellency, I shall turn to the second part of my submission, which deals with the applicable test for permission to amend a statement of case. Your Excellency will undoubtedly already be familiar with this, but in the interest of time, I propose just to deal with it summarily by going through the points I've set out in my skeleton. I think the first point to note, Your Excellency, is I don't think there's a huge amount of disagreement between Ms. Chung and myself as to what I call the threshold test, which is that in order to grant permission, the amended or the proposed amendments must be properly pleaded and they must demonstrate a real prospect of success. So I think we're agreed on that, and we both rely on the Court of Appeals judgment in Oman Insurance and GlobeMed Gulf Healthcare Solutions. I have dealt with what is meant by the phrase properly pleaded in my skeleton at paragraph 22, relying on the dictum in the High Court case of various air finance leasing companies and Saudi Arabian Airlines Corporation. I invite Your Excellency to reread that in due course, but the net effect of it is that a properly pleaded particulars is one that provides all the right particulars. It identifies exactly what the parties need to understand the case, and it's comprehensively, and it's also one that's comprehensible to the respondent. What constitutes a real prospect of success is also trite law. It's not a particularly high bar to meet, and it merely requires an applicant to demonstrate that he has more than a merely arguable case that can be advanced with some degree of conviction. I've dealt with this at paragraphs 23 to 25 of my skeleton. It suffices just to draw your attention to Chief Justice Zaki Azmi's judgment in Oman Insurance and Global Gulf Healthcare Solutions, and I've set that out at paragraph 23 of my skeleton. From what I have seen from Ms. Chung's skeleton, I don't understand there to be any real challenge to whether the amendments have a real prospect of success, but I may need to hear from Ms. Chung further before I can respond to that. Once the court is satisfied that the threshold test has been met, the court will then move on to consider other factors to decide whether it should or should not grant permission. And there are two categories of applications, Your Excellency. The first category is where there is an issue of lateness, and the amendments, if granted, would likely lead to an adjournment or threaten the trial date. And there's a second category of cases where there is no issue of lateness, and the granting of permission will have no adverse impact on the trial date. In my submission, this case clearly falls under category 1, because there is currently no trial date set and no other directions. Ms. Chung, in her skeleton argument, seems to suggest this is a late application and seems to imply that it falls under the latter category, albeit I'm not quite sure how that argument is made out. The factors that the court will need to take into account where lateness is not an issue is set out at paragraph 26 of my skeleton argument. Briefly, they are that the court must exercise its discretion having regard to the overriding objective, and that is to deal with cases justly and at proportionate cost. Secondly, the court must strike a balance between the injustice to the applicant if the amendment is refused versus the injustice to the opposing party if the amendment is permitted. And thirdly, the court must have regard to dealing with cases justly and at proportionate cost and ensure that the court's resources are properly allocated. So, Your Excellency, with the legal framework in mind, I'll now turn to the third part of my submission and take you through the proposed amendments to the particulars of claim. And whilst I'm doing that, I'll address you on why, in my submission, they more than clearly meet the threshold test. I have set out my full submissions on this in my skeleton at paragraphs 29 to 36. If I may ask Your Excellency to go to C16 to begin with, I'll direct the court to the page. This is the re-amended particulars of claim for claim 107. And just before I take you through them, Your Excellency, the amendments fall under two categories. Firstly, they are corrections to ensure that the information set out in there is in fact accurate and correct. And secondly, it's the introduction of the alternative claim in restitution. The first change that needs to be made, it's at page C18, paragraph 7.2. It hasn't been marked up on the draft exhibited, but it's simply a mathematical correction at paragraph 7.2. Instead of 257,500, it should read 265,000, which is obviously 132,500 times 2. The next amendment is at paragraph 9, which can be found at page C23. And again, Your Excellency will see this is simply a correction. We had put in the wrong year for the legislation as saying number 16 of 2011 when it should be number 12 of 2004. So these are merely corrections to ensure that what's stated in the particulars is accurate. If I may now ask Your Excellency to move on to C27, which is the new section VA. This deals with the introduction of the alternative claim in restitution, which is a claim that is pursued against the first defendant only. Now, the court is undoubtedly well versed in the law relating to restitution for unjust enrichment. However, to put these amendments into context, it may be worth refreshing the court's mind on what my clients would actually need to prove. in order to succeed on a claim in restitution. This will allow the court to assess whether the amendments are properly pleaded and have a real prospect of success. Your Excellency, the first requirement, of course, is that we must show the defendant has been enriched. And in this case, we say enrichment is through the first defendant's receipt of monies from each of the claimants. Now, paragraph 14b and 14c provides the full particulars of how much was paid by each claimant to the first defendant, including when those payments were made. It follows in my submission that there isn't really any further information that the claimants could conceivably provide as to enrichment. It's got everything that the defendants would need to understand about how we say the first defendant has been enriched. The second requirement is that we must show the enrichment is at the claimant's expense, and paragraphs 14b and c are equally applicable to this limb, because again, we've provided all the information about when the claimants made each of the payments and in what amount. The third requirement will be that the enrichment must be unjust. Now, there may be one or more reasons why enrichment may be unjust, but that normally includes because it's been made under a mistake, duress, undue influence, failure to provide consideration, whatever else it may be. Paragraphs 14 D, E, F, we have identified that the payments were made under a mistake of law and fact, and we've provided the full particulars as to why the claimants were mistaken in providing the sums to the first defendant in those particular paragraphs. In summary, if the defendant's case is correct, all of the monies were paid under the mistaken belief that the claimants were providing these sums pursuant to legally valid, binding and enforceable agreements. Now, Ms. Chung in her skeleton at paragraph 13 submits that the amendments are not properly pleaded because she says there's no reference to the law on which the claim in restitution is based. What I would say firstly to that, Your Excellency, is if that was in fact a genuine concern of the defendants, there is absolutely no reason why this should not have been raised with the claimants prior to the receipt of Ms. Chung's skeleton argument last night, and the clarification could have been provided. On the 3rd of February, when the defendants responded to the draft amendments that had been sent to them, they simply said they would oppose the application. They raised no issue with the amendments themselves or sought any clarification. Secondly, in any event, Your Excellency, you do not normally plead law in particulars of claim. The proposed amendments are in accordance with what is set out in RDC Rule 17.17 as to what the contents of a particulars of claim must include. Moreover, given this dispute is before the DIFC court, and there has been no challenge to the jurisdiction of this court, DIFC Law number 3 of 2004, which is the law on the application of civil and commercial laws, would apply. And therefore that provides that English law would govern this claim in restitution. Notwithstanding all of that, if that is the only complaint the defendants have, with respect and in my submission, it is a very trivial complaint, and it's one that is easily fixed with the addition of a sentence. And it should have been communicated to us before, rather than forcing us to the stage where we are at now, of having had to make this application and incur the cost of doing so. It is also clear, moving on from that, Your Excellency, that the alternative claim in restitution has a real prospect of success. Indeed, Ms. Chung does not seem to address this or challenge it at all in her skeleton argument. So I will simply refer the court to my skeleton arguments at paragraphs 32 to 36 as to why I say this clearly has a real prospect of success. Now, Your Excellency, the amendments to the 108 particulars of claim can be found at D15, and I can go through these very quickly because they are almost a mirror of what's in 107. The first amendment is at paragraph 7.1.1, which is at D17. Your Excellency, this is, as you'll see from the amendments in green, it's merely just to correct the position factually. What the original text said is that a loan of $100,000 had been advanced to both the first defendant and the second defendant. That's not correct. It was only £100,000 from each claimant to the company. So therefore 7.1.1 is just a correction of that to make sure it's factually accurate. The next correction is at 7.6.1. Again, this is a reference to CLA3, which is not defined in this particular claim. It should just be loan agreement. So that's a correction to make sure that makes sense. The next amendment is at paragraph 9, which is at D21. And again, as with the 107 particulars, this is just to correct the legislation number and date. And at D25, lastly, the court will find section VA, which is the introduction of the claims in unjust enrichment. Now, these amendments for the restitution claim are almost in identical terms to what I've just taken the court through in respect of the 107 particulars, save for the amounts paid by the claimants in this claim to the first defendant, and the dates of those payments are different. And that, again, is set out at paragraph 14b here. So, Your Excellency, the submissions I made in respect of the restitution amendments to the 107 particulars equally applies to the restitution amendments in the 108 particulars. And as such, I won't repeat them here, save to say that even these amendments are clearly properly pleaded. They provide full particulars of the facts, all the information the defendant needs to understand the case we're bringing, and is also coherently pleaded. And the amendments do have a real prospect of success. Your Excellency, in dealing with the threshold requirements, I'll now move on to the other factors, having gone through why the claimants in my submission comfortably meet that threshold requirement. There are, in my submission, no other factors militating against the court granting permission to amend the particulars of claim. My full submissions on this are set out at paragraphs 37 of my skeleton arguments. So I don't plan to repeat those submissions in my skeleton. What I will instead do, Your Excellency, is focus on some of the points raised by Ms. Chung in her skeleton argument. Now, it would appear that the defendants devote most of their energy to criticising the timing of the amendments, as well as alleging that there has somehow been a delay, which lies at the doors of the claimant. With the greatest of respect, those arguments are incomprehensible. They're factually inaccurate in large part, and they are wholly misconceived. It is clear in my submission that there is no lateness or timing issue in respect of this application. If permission were to be granted today, it would not interfere with any other procedural milestone or the trial date, simply because none of those have yet been fixed. The claim is very much still in its infancy. Ms. Chung's submission on delay is set out in her skeleton argument at paragraphs 23 to 26. In my submission, what she sets out there simply ignores the reality, which is that the defendants have failed to engage in this process from the start to such an extent that the claimants obtained default judgment. And Your Excellency will be familiar with this because Your Excellency dealt with one of the applications to set aside, I think, the 108 judgment. So it's all well said for the defendants to say the claims have been ongoing for a year and these amendments could have been pleaded at any point within the year. However, in my submission, that argument fails for two reasons. Firstly, because by July 2022, both claims were considered concluded because the claimants had obtained judgments on both of them, and they had even started the process of enforcement. And it's only when they started the process of enforcing the two judgments that the defendants finally started to engage. And that was around October 2022. So the two default judgments themselves remained in place and were not set aside until November and December 2022. And that is the stage at which the claims are reinstated and the court sets down directions for a defence to be filed and for a reply to be filed. So the submissions simply ignore reality, which is there was no point for us to amend on a claim on which we had already obtained judgment. It's simply not logical. It is only in December 2022 that the defendants formally submitted a defence seeking to challenge the validity and enforceability of the loan agreements and the guarantees. Now, Ms. Chung, in her skeleton argument at paragraph 7 and 23b, says this was raised at the first opportunity possible in October 2022, by a witness statement in support of a set-aside application. The statement to which Ms. Chung refers to is the third witness statement of Mr. Ray Chowdhury, who's one of the defendant's solicitors dated 17th of October 2022. Your Excellency, that witness statement was not in the bundle. I had asked for it to be provided to the court this morning. I don't know if you have it in front of you.
Yes, I do.
Yes, so I'm grateful for that, Your Excellency. It's worth having a read of it because, as I say, it doesn't quite reflect what Ms. Chung says it does. Paragraph 7 is, I think, what Ms. Chung is referring to, and all he says there is about 3 lines down. Moreover, the defendants indeed have a proper and substantive defence. For instance, the award of 12% interest is wholly against the laws of the United Arab Emirates, where it is illegal to grant a loan on interest by an individual to another individual or a corporate. Only licensed banks and financial institutions in the UAE are allowed to loan money on interest. In this respect, reference is drawn to 458 in Article 59, I think that's supposed to be 459 of the UAE Penal Code, and then they quote the relevant provisions, and they say 9, by their own admission, the claimants were based in Dubai at the time of the transaction in question. Accordingly, all laws of the UAE, including any and all penal laws, shall apply to their conduct. And then it goes on to the fact that they're litigants and persons. So that is all that is referred to in this witness statement, and it does not state anywhere in the statement that the defendants were alleging that the loan agreements or the guarantees stand null and void as they now do. The most that could be inferred in my submission is that the defendants may have challenged the claimant's claim to contractual interest, not the agreements themselves. That's why he simply refers to, for instance, 12% is illegal. So there is absolutely no clear and unequivocal statement here that they plan to challenge the validity and enforceability of the agreements. Only interest is referred to. In any event, the claimants had no reason and could not have applied to amend the particulars of claim, as I've said, in circumstances in October where it had already obtained judgment. The earliest this could have been done was after the judgments were set aside, and that was in late November and December 2022. And the defendants were subsequently filed in December 2022, the 14th and the 26th. And that's the first time the defendants unequivocally say that loan agreements and the guarantees are null and void as a matter of UAE law. As such, any suggestion by the defendants that the amendments we now propose could have been advanced earlier is nonsense. It has been advanced at the earliest possible opportunity once the defendants unequivocally and clearly set out their position. The application itself is not late, as it could not have been made earlier. Moreover, the application does not risk delaying any other procedural milestones, nor does it require the parties to revisit any significant steps already undertaken in the litigation. Ms. Chung's reliance on the case of CIP Properties and Galliford, which is an English authority by Mr. Justice Coulson, as he then was, at paragraph 24 of her skeleton, is misplaced. She relies on that authority to say lateness is a relative concept, and just because an amendment could have been made earlier means that it's late. It's a very fact-sensitive analysis that the court has to undertake. And in that particular case, despite the application having been heard 8 months prior to trial, the court found it was late because permission had been sought after disclosure had taken place, which was a significant step in that litigation. And it was also threatening the trial date if the amendments were to be allowed. So that case actually reinforces the point that, as to timing, which is that an application will only generally be considered late where it threatens to vacate the trial date and where the parties will have to revisit significant steps that have already been undertaken in the litigation. That's simply not the scenario that we're faced with here. The next point Ms. Chung appears to submit at paragraphs 15 to 21 of her skeleton is she says there is no good reason to allow the application to amend because the claimants ought to have known that the loan agreements and guarantees were invalid and unenforceable under UAE law, and they should have accounted for this being raised as a potential defence. First of all, no good reason is not the test that the court is dealing with here. It's the threshold test plus the other factors. Secondly, that submission is also entirely misguided for two reasons. Firstly, it is not accepted that performance of the loan agreements and the guarantees are contrary to UAE law. It is very much the claimant's position, as set out in their reply, that the interest-bearing loans provided to the first defendant are entirely legal and legitimate in the UAE. Secondly, Ms. Chung's argument is undermined by the fact that the defendants rely on Articles 458 and 459 of the Penal Code, but the wording of those articles make it crystal clear that concerns interest-bearing loans from a physical person to another physical person, i.e. between two natural individuals, whereas this case concerns an investment by way of a convertible loan from a physical person to a corporate entity that is based outside of the UAE. So Article 458 doesn't even address that circumstance, and they haven't cited any other provisions of the UAE law that actually refers to the illegality of that. By contrast, in our reply, we have referred to the commercial transactions law, which we say govern these arrangements insofar as UAE law is relevant, and we've pointed out the relevant provisions that provide for interest-bearing loans being permitted and the contractual rate governing what the interest is to be. So in those circumstances, Your Excellency, the claimants could not have conceived of a claim in restitution where the agreements are valid under their respective governing laws, which is English law, but they are also lawful in the UAE where they are based. So I don't accept Ms. Chung's argument at 15 to 21 of her skeleton, and I say it's completely misconceived for those reasons. If I may move on to the final point that the defendants advance, and this is the point that's set out at paragraphs 27 to 30 of Ms. Chung's skeleton. She says that the amendments would duplicate costs in that the defendants would have to seek legal advice on the merits of the amendments and the amendment of to its defence itself. The factual basis of our claim in restitution is identical to the main claims in debt and the contractual claims. We haven't advanced any new facts. We have simply used what is already there to advance an alternative claim. Now, the defendants have, in breach of RDC rules 17.26 and 17.27, in their defense, they have failed to address the factual allegations at all. They have merely advanced a bare denial. They don't deal with each factual allegation, which is contrary to the rules. So as such, where this argument is advanced that this is going to lead to a duplication of costs and efforts and everything else, it's unclear to me how that can be the case, where the facts are exactly the same, and no, there's been a complete failure to respond to the main claims in the first place. So what additional efforts or costs are the defendants going to go to? If anything, they're going to be dealing with the factual allegations for the first time, which they should have done back in December 2022. So, Your Excellency, for all of those reasons, I'd say there is no valid grounds that the defendants have put forward as to why permission should be refused. And for those reasons and the reasons I set out in my skeleton, I invite the court to grant permission to allow the claimants to amend their particulars of claims. Your Excellency, unless I can assist any further at this point, those are my submissions on the substantive applications.
Thank you. Ms. Chung, your turn.
Your Excellency, I bring three main submissions today in this hearing. The first, that there has been no good reason, that is, no good explanation at all has been identified in this amendment application. The second is that there is an unjustified amount of delay. And lastly, that is duplication of costs and efforts. And we say that overall, it is in the interest of justice that the defendants ought not to be jerked or mucked around by the claimants as such. You will see, of course, that at paragraph 13 and 14 of my skeleton, I have made a very short point on whether the proposed amendments are properly pleaded. I don't propose to cover those in my oral submissions because the skeleton is perfectly clear and stands on its own. However, I note that the reason why that these comments have been made is because there is precisely in this case an interaction with UAE law, DIFC law, and allegedly English law. So it is important for the defendants to actually know the precise applicable law and against it. And that is particularly so given that at Section 5 of the amended particulars of claim, it deals with the applicable law and jurisdiction which the claimants are relying upon. And it is important to know for the defendants to know actually whether that section also applies to the restitution claim. Before I properly start in on the submissions, I would just like to take Your Excellency to the legal principles. Now, my learned friend has already taken you to much of them, and I do agree that we are mostly in agreement as to the principles applicable here. But I would just like to highlight the following. If I could just take you to my skeleton at paragraph 11, where we have Chief Justice Zaki Azmi's commentary in Oman Insurance Company. And if I can just ask you to take a look at paragraph 21, at the very last sentence, he says, dealing with the case justly includes considering the amount of money involved, as well as ensuring the case is dealt with expeditiously and fairly. And we say that this is important to bear in mind when assessing the interests of justice and the balance of all the factors. If I could then ask you to look at CIP properties, which is set out in paragraph 12 of my skeleton, we say this is a very helpful summary of considering applications to amend statement of case, of which, of course, both the English courts and the DIFC courts have had much authorities already. We can just take a look at subparagraph A, and we do submit that this is important because there is a contention that this application today is not late. Well, we say the dicta is perfectly clear. The lateness by which an amendment is produced is a relative concept, and it is fact sensitive. But it does say that an amendment is late if it could have been advanced earlier or involves the duplication of costs and effort. And we say that both these parts have been met in this claim. There has been a suggestion by my learned friend that an amendment application is not necessarily late if it doesn't imperil the trial date. Well, that's not true if you look at subparagraph B, where it says that an amendment can be regarded as very late if permission to amend threatens the trial date. So if anything, all this shows us is really lateness is simply where an amendment could have been advanced earlier, and it is certainly incredibly late, very late, if it threatens the trial date. And we say that in the interest of justice here, as I will cover later in my submissions, it is late and it should have been advanced earlier. If I can then take you to subparagraph C, this is the reason why there is a submission as to the explanation for its lateness, because the history of amendment and together with an explanation for its lateness is a matter for the amending party and is an important factor in the necessary balancing exercise. There must be a good reason for delay. And of course, this is common sense, because if there isn't a good reason, then the defendants or the party resisting the amendments is going to be mucked around. They're going to have to consider the case afresh, and they must start preparations again, because the pleaded case is the case against them. Then if I can ask Your Excellency to look at subparagraph E, what is the prejudice essentially to the resisting parties? Well, on one end of the spectrum, it's simply the fact of being mucked around. But there is also, of course, disruption and additional pressure on the lawyers in the run-up to trial, and the duplication of cost and effort. And we say that the reason why my learned friend has focused on the adjournment of a trial date is that if the trial date were imperiled, then that is an overwhelming reason to refuse the amendment. But of course, here we are looking at the other end of the spectrum, and we're not considering that problem here. However, the authorities are quite clear that even the simple fact of being mucked around, the duplication of cost and effort, is to be taken account when the trial date is not being imperiled. Lastly, subparagraph F, which again we say is important because we say the explanation is not good. The prejudice, of course, to the amending party is obviously its inability to advance the amended case, but that is only one factor to be considered. If that prejudice has come about by the amending party's own conduct, then it is a much less important element of the balancing exercise. Having just taken you through the legal principles, I start then on the first submissions. We say that it is late because there is no good reason that a claim in restitution wasn't pleaded earlier. We say that the need for these applications is essentially due to the claimant's own conduct of the case. In the premises, any prejudice suffered in the dismissal of these applications will have been authored by its own hand. Now, the reason the claimants allege they need to bring these applications now, as opposed to earlier, is because the defendants have never previously alleged that the loan agreements were void under UAE law. Well, simply that isn't a good reason that it wasn't first pleaded in the particulars. Your Excellency, the claimants have been legally represented throughout these proceedings from the very start, from the very first demand. It should have been clear to its legal representatives, who are clearly experienced litigators with the experience of both onshore and offshore courts and the laws involved, that this was a potential defense to the defendants. It is uncontroversial, of course, that restitution only comes to play if there isn't a contract. But the claimants do have a responsibility to consider what needs to be in their statement of case. They are the claimant. They have the luxury of choosing when to issue, what facts need to be pleaded, what claims to bring when they issue, and time to consider how to shape the pleadings, including what defenses that might be brought against their own claim. It has been repeatedly said by my learned friend throughout that these are identical facts, that they are simply advancing an alternative claim. Well, the query from that is that if they were identical facts, why wasn't this claim pleaded in the alternative earlier? Well, the claimants then expand on that and say, well, actually, we don't think that this penal code applies, and really it's about the civil transactions law. And they say that the contract is enforceable from the very start. Well, what rather begs the question then as to why this amendment application is needed at all. If the civil transactions law is a complete answer, then this amendment application is wholly unnecessary and no prejudice is caused to the claimants by the dismissal of this application. We say that the defendants are doing as they are entitled to avail themselves of the defenses which are available to them. To blame the defendants for having a defense which the claimants haven't considered, despite having the luxury of time and legal representation, well, that just isn't good enough. And therefore we say that this is a factor to bear in mind. This is not a good explanation as to why the amendments are pleaded now, as opposed to earlier. And even on the claimant's case, it rather begs the question, if the civil transactions law is a complete answer, why this amendment application is needed anyway then. The second point relates to delay. And we say that there is unjustified delay because the claimants were well aware of this position nearly half a year ago. As I've said before, this claim was started a year ago. And we say this is important because of the previous point. The claimants should have known about this potential defense at the point when they were pleading the identical facts that found their alternative claim in restitution. They knew of this back in mid-October 2022. Now, my learned friend has asked you to look at the set-aside application, and I'm afraid I'm going to have to ask you to do the same. And we are looking at this exact same paragraph, paragraph 7. Now, my learned friend opposite has said that this tells you nothing. That all it says here is about the award of 12% interest being against the laws of the UAE. But that seems to be splitting hairs. If I can just take you to the last 3 lines in paragraph 7, it says, it is illegal to grant a loan on interest by an individual to another individual or a corporate. Only licensed banks and financial institutions in the UAE are allowed to loan money on interest. Well, Your Excellency, the defendant's defense then is plain as day. The corollary of those 3 sentences is that the loan agreement is null and void. The claimants say, well, it doesn't explicitly say that the loan agreement and guarantee is null and void. Your Excellency, that's just splitting hairs, and I'm afraid that it just isn't a good explanation. From the date of October 2022, in the set-aside application, the defendant's position was entirely clear. Now, the second point, of course, that the claimants say is that the set-aside was done on 12th of December. They couldn't have put this in before the defense was formally filed. Now, the set-aside application was done on 15th of October. The set-aside judgment was granted on 12th of December. In essence, the claimants knew of this position for 2 months, and it's not exactly clear as to why an application to amend was not made then, when the set-aside judgment was granted. I'm now going to take you to the applicant's authorities. And I would like to take you to Orion Holdings at page 8 of his bundle, at paragraph 25. Your Excellency, for your information, this is also the same case that was cited in the witness statement supporting the dismissal of this application by the third defendant. If I can just ask you to look at paragraph 25. One of the reasons why the judge in that case considered that the amendment application had been made early in those proceedings was because it had been served on the first and second defendant and prior to any defense being filed by the third defendant. And as a result, the defendants were not prejudiced procedurally as a result. Well, we say that this dicta is really a complete answer to the claimant's point made in his submissions just now. It was more than possible, having known of the defendant's position 2 months ago, it was entirely possible for them to put in the amendment application then, before the defense was filed. But even if we take the starting date of their knowledge, which of course is not accepted, but even if we take the starting date as the defense filed on the 26th of December, well, it was nearly 3 months ago. By now, a statement of reply has already been filed. In fact, if we look at the whole timeline, it's arguably been some 5 months, nearly half a year after they knew of the defendant's position that the loan agreement and guarantee was null and void. And it's been some 3 months after the filing of the defense. Even on the best case scenario, then, the claimants are late and there is no justified delay for making this amendment application. Not only could it have been advanced earlier from the very first time these pleadings were brought over a year ago, but it could have been advanced either 5 months ago, nearly half a year ago, or 3 months ago, before the defences were filed and before the reply. Your Excellency, the prejudice to the defendants is clear. The defendants simply don't deserve to be mucked around even further. This amendment application has already resulted in the adjournment of the CMC. Had it been brought earlier, this wouldn't have been necessary. It has a result in yet further delay in these claims hanging over the defendant's head, which has been hanging over the head for over a year. And if these applications are granted, the defendants are going to have to adjust to a new cause of action and consider the case here against them afresh. Other than delay, of course, there is the third point, which is the duplication of costs and efforts. Well, it is the case, isn't it, when now that new pleadings have been filed, the whole process has to restart. We start with the particulars, we're going back to the defense and the reply. Every procedural step which has been taken in these proceedings so far needs to be revisited. At this point, all pleadings have been filed and the parties have an ample opportunity to consider the case it wishes to bring and the case against it. And the corollary of that, of course, is the parties have already incurred all the costs relating to the pleadings, and of course, including costs such as advice from its legal representatives as to the merits of the case against it, what causes of action or defences it ought to bring. The substantive amendment that the claimants have raises an entirely new cause of action, which means the defendants are going to have to incur the costs of seeking legal advice as to the merits of the amended particulars, amend a defence, and consider afresh what other defences are available to it to defeat the new restitution claim. Essentially, the change proposed renders the defendant's previous efforts in these proceedings entirely negatory. All procedural steps have to be redone. We say that given that the explanation is simply not good, given that they could have made these amendments over a year ago, or even 5 or 3 months ago. It is simply before some of these procedural steps were taken, the delay is unjustified. And we say that the duplication of cost and efforts as a result is also unjustified. We therefore submit it's not in the interest of justice to mark the defendant around further, and we therefore respectfully invite the court to dismiss these applications. Your Excellency, if those are my submissions, unless I can help you any further.
Thank you. Mr. Mheiri, you want to reply?
Just a couple of short points, Your Excellency, if I may. The first point relates to what Ms. Chung said, which is she says, if the civil transactions law is the complete answer, then it begs the question why the amendment is needed at all. I don't fully follow that submission. First of all, it's not the civil transaction law that's the complete answer. That's what the defendants allege applies in this case. We say it's the commercial transaction law that applies. But in any event, it is the defendants who have put into issue whether these agreements are invalid and unenforceable as a matter of UAE law. So in those circumstances, that is an issue that is now in dispute between the parties. And it's incumbent upon the claimants to ensure that, having been told that, they advance the other causes of action, which are based on the same facts, to make sure that they're not prejudiced at the end of the day. Because the net consequence of what Ms. Chung is saying, and she hasn't expressly said it, but it's implicit, is that the defendants seem to be operating under this conception that if they get home on the defense, then the money is theirs to keep. And that simply is not the case, and that's not what was intended. So what is it that the defendants say should happen if they were to succeed on their defense? That is why we're now applying to introduce the alternative claim in restitution, which is to close that hole, that loop that exists, that we didn't know existed at the time that we issued the claim. The second point that Ms. Chung says is, she says, well, if you look at the set-aside application and the witness statement of Mr. Keisha, well, that's just splitting hairs. We haven't actually said it unequivocally, but we refer to the interest. So you can only infer that the agreements are invalid. Well, with respect, that's simply not good enough, because it's not for us to infer what the defense is going to be. If they wanted to unequivocally state that the agreements were invalid and unenforceable in that statement, they could have done. The fact that they referred only to an interest provision as being against the law of the UAE tells us nothing, because the contracts themselves, and if I may show you an example of CLA 3, you can see at A25, there's a severability clause that exists, which says that even if a provision of the agreement becomes invalid, illegal, or unenforceable, it's modified to the minimum extent necessary to make it valid, legal, and enforceable. So by saying and focusing only on interest in the statement, that in itself does not mean the whole contract is invalid, because there's a clause in the contract that specifically says it will be modified in those circumstances. So it's not a case of splitting hairs. Precision is key. Unless you tell us what your case is, we can't understand it. The first time that happens is in the defense. The last point I wish to deal with is the kind of blurring of the lines between, oh, this could have been advanced 5 months ago in October or 3 months ago when the defense was served. The running order of things, Your Excellency, was we got the defense. We were directed by the court to file our reply within 2 weeks, which we did. At paragraph 3 of our reply to claim 107, we expressly reserved the right to apply to amend the particulars of claim to introduce a restitution claim. And that's on the basis that Rule 17.50 makes clear that you must apply to amend as opposed to introducing a new course of action into your reply. And we provided those amendments within 2 weeks of filing the reply. So come what may, because the defense was the first time they ever took and adopted this position that the agreements were invalid and unenforceable, they would have always had to go back and redo the defense, even if we had applied there, because the defense was the first time we ever heard this submission being made in the way that it was made. So I don't accept what Ms. Chung says. And lastly, Orion Holdings, Ms. Chung took you to and said, look at paragraph 25. In that case, it was early because it hadn't been served, no defense had been filed. That was very specific to the facts of that case. It also conveniently ignores Oman Insurance, for example, where permission was granted. And in that case, that was 2 years after the pleadings had closed, and the court still determined that it was justified in granting permission. So Orion Holdings doesn't establish any proposition that it's only an early application. All the authorities, the English authorities particularly, are divided into two, where lateness is an issue and where lateness is not an issue. And what determines whether an application is truly late is the impact it will have on the trial date and other procedural milestones that have been set in place. None of that has happened here. All that has happened is pleadings. There's been no directions, no disclosure, no statements, no expert evidence, nothing. So it will interfere with none of the rest of the litigation. They are based on the same facts. Any consequential amendments are going to be limited. And quite frankly, I would be surprised if the defendants even put in anything in response to it were we given permission, given the way in which they've approached their defense to the main claims. Your Excellency, I have nothing further to add beyond to that.
Ms. Chung, do you want to reply briefly?
No, no, Your Excellency, except to point out that you have subparagraphs A and B at CIP properties, which tells you that it's not merely a matter of being truly late, only if the trial date gets imperiled. Rather, it is late simply if it could have been advanced earlier. I think that's the only point I would take. Thank you, Your Excellency.
Okay. Thank you both for your submissions. The registry will revert to you in relation to my order.
I'm grateful, Your Excellency.
Thank you both for your time. Thank you.